If you planned your life around a 5-year ILR clock, this update can quietly destroy your timeline unless you act early. And today, I'll tell you exactly why. Subscribe now because the biggest UK immigration changes are landing on settlement routes first, and most people find out too late. Hello everyone, my name is Kayani. I'm a UK immigration, family and a human rights solicitor regulated in England and Wales with almost 20 years of experience. Here is why people are panicking. Families come on lawful routes thinking 5 years, then stability. They chose schools, committed to jobs, signed tenancies and planned for universities. That 5-year line became the finish line. Now the finish line is being redrawn. The turning point. The earned settlement consultation closed few days ago, 12th of Feb 2026. The Home Secretary told the Home Affairs Committee there were around 130,000 responses. This is not a rumor. It's a redesign in motion. Now the key question, can the new system affect people already in the UK before they reach ILR? Her evidence strongly suggests yes. She said it is inconceivable that nobody currently here would be affected. And the consultation asks directly about transitional arrangements. So the real fight is protections, exemptions, and who is shielded. But there is the twist. Consultation closed does not mean the law changed overnight. Ministers now sift responses, finalize policies, then implement through immigration rules and statement of changes. And because rule changes often happens at least twice a year, speed is possible. That is why delay is dangerous. Now, a retrospective in plain English is that the Home Secretary emphasized that ILR is assessed under the rules in force when you apply, not the rules when you arrived. So if you qualify under today's rule but delay, saving for fee, waiting for right time, a new rule can arrive first and you may be judged under the new framework unless transition protection is written in. Remember, this eligibility plus delay equals risks. Now, fairness matters too. Public law can require fairness where people relied on published pathways. Cases like HSMP Forum are the warning sign. That is also the Law Society has urged that reforms must be fair and avoid retrospectiveness. Where do children fit in all these circumstances? The Home Secretary indicated the children in care or unaccompanied children are out of scope, and some commitment for children who grew up here without status remains unchanged. But wider questions about dependent children in working families are still open, and that is why parents feel it. For a child, another 5 years is not policy, it's insecurity. So here are your practical steps. First, do a settlement audit, route, dates, absences, compliance, tax and national insurance record, English language requirements, life in the UK and any character issues. Second, build your ILR file now, passport, travel history, status proof, payslip, P60s, bank statements, tenancy or mortgage statements and evidence of continuous lawful residence in the UK. Third, don't let fee control your clock. Fee planning is legal strategy. Fourth, if you have no recourse to public funds, get advice before you act. Fifth, if children are involved, show best interest with evidence, school progress, stability, and real-world impact. If you are close to eligibility, don't drift. Get a proper check, gather documents and file at the safest point. Prepared people don't panic, they position. I'll say it again, prepared people don't panic, they position. Subscribe now. See you soon. And here is the promise. In the next video, I'll break down transitional protection, who might be exempt.